as our fellow conferees continue to join us, we will get started. I hope everyone had a good lunch. We did. And we are looking forward to proceeding with this afternoon's session. We will begin with what I know is going to be an extraordinary conversation on the rule of law and legal certainties in current democracies. A reminder to our speakers that we have until 4:20 to complete this panel, so I will kindly ask that everyone adhere to the time limits. First, I would like to make sure that all of you have in your hand a bookmark, either in English or Spanish or French or Portuguese. Yaki, have those been distributed? Those were sent by Justice Kennedy to all of you, and if anyone is missing your bookmark, please raise your hand. I didn't get mine, so I'm raising my hand, and our team will bring some in and distribute them to you. It was a quite wonderful thing for the Justice to do. I'm not sure if I'll get one or not, but I'm going to keep my hand up just in case. Thank you, Deborah. Thank you, Deborah. Secondly, to the press, as we proceed with this next panel, I will kindly remind you to turn off your camera during the remarks of Justice Stephan Harbarth, as his speech is not to be recorded at all. And now I'm going to try this in Spanish, so please do not laugh at my bad pronunciation. Pedimos de la prensa que por favor apague las cámaras durante la intervención del magistrado Stephan Harbarth, ya que su discurso completo no puede ser grabado. Was that close?
Let me say. Agradecemos a los medios, por favor, a apagar sus cámaras al momento en el que vaya a hablar el presidente Harbarth, ya que su discurso completo no puede ser grabado. Gracias.
My apologies for my terrible, terrible Spanish pronunciation. And now I am very honored to call to the stage our keynote speaker and moderator, President Egils Levits, who was the president of Latvia from 2019 to 2023, and judge of the European Court of Justice from 2004 to 2019. I also invite our panelists, Matej Accetto, President of the Constitutional Court of Slovenia, and Stephan Harbarth, President of the Federal Constitutional Court of Germany. And Senior Justice Kennedy will provide his remarks on video.
Dear colleagues, first of all, I would like to thank Javier Cremades for the organizing of this event, very important event when we can meet colleagues from different countries, from different continents, and exchange our views on the same topic, which is common to us, democracy and rule of law. And today, by this panel, we will focus on the relation between democracy and rule of law. In everyday language, we are speaking that our state form is democracy, but it is a very short abbreviation, because democracy is only one part of our state order. The modern state order consists of three elements, three fundamental elements. One of them is democracy. The second one is rule of law, and the third one, human rights. And altogether, makes our modern state order. And in German, there is a special term for that. This is demokratischer Verfassungsstaat. It's not so common also in English-speaking world, democratic constitutional state. But I think in order to see that democracy is not the only one element, we should, as lawyers, also at least today, use the term democratic constitutional state. And democracy, fundamental rights, and rule of law are interconnected with each other. First of all, I would like to say that there is a natural tension between democracy and rule of law. Fundamental rights is a result when both rule of law and democracy are functioning well. When they are not functioning well, the relation between them there is interferences in that, then of course fundamental rights suffer also. Also concerning to the structural problem, not the political problem, but the structural problem of the democratic constitutional state, this tension between democracy and rule of law. Democracy means also in general that the will of the people, which is expressed in a certain procedure, transforms to laws, transforms to politics. But there is nothing said about the content of this will. This will could be very, very different. And in order to have a certain limits of democracy, rule of law is restricting democracy in a certain specific way, restricting democracy. And of course, constitutional control, and there are representatives of many constitutional courts. There are the institutions, maybe as the most important institutions, maybe not the only one, but the most important institutions, which have the task to restrict the democracy, to restrict decision of the government or the parliament, which is a result of democracy. And I think exactly this was after the Second World War not very by the classical functioning of democratic constitutional state, not very disputed. But in the last 10-15 years, this relation is in crisis, I would say, disputed. And disputed not only in the newly established democracies, but also in the very old democracies. By the way, that means that the democratic constitutional state is not something natural, self-evident, and you cannot rely on 200 years of history. Each generation should learn again and again. And the next generation should also learn this complicated relation and complicated mode of functioning of democratic constitutional state. And obviously there is now this relation, democracy is in crisis. We can easily see that democracy since maybe end of the 90s, beginning of the 2000 years, there was an intention to widen the democratic participation, so-called democratization of democracy. The colleague from Guatemala told us the earlier stage of democratization of democracy. The first voters were only male taxpayers, then all males, then literate women, then all women, and now all formally are participating. And the second wave of the democratization of democracy means to invite all the social groups to participate in politics. Also because not all the percentage of voters is 50 to 70%, so not all, but there are activists and our political parties are saying, come into democracy and participate. And this expansion of, or democratization of democracy, element of democracy, has not, so to say, is not really reflected also in the quality of democracy, in the quality of the democratic decisions. And we can see that especially through digital media, so social networks, also such political agendas are promoted, which would be very difficult to be promoted in the system of certain filtration through parties, filtration through responsible press. So to say, not all ideas which we are exchanging in our kitchen are ready to be discussed in the parliament, in the public. Now it is possible. And therefore, this quality of democratic discourse, I would say, democratic debate, is problematic. And one of the problematic issues of this discourse is that with a wave and with the idea of equality on participation, of course, the focus is put to the restrictions of democracy by rule of law, by the courts, by constitutional courts especially. And there are many discussions also in the academia whether whether such kind of restrictions are still democratic, and whether this outsourcing of certain competencies to the courts, to the independent agencies, especially in the European Union or in the European Union as such, where I'm speaking now about the European Union, where the voter has relatively not so direct influence to the decisions of the European Union, has not created a certain frustration, and this frustration is used by populists, or the populists are making this feeling of frustration in political money. And they are in all, or in most democratic states, we can see that there are such populistic movements which are challenging exact this classical relation between democracy and rule of law. The problem is how to deal with that. And first problem discussed also in academia, but also in a broader public, is whether it is good or bad. So to say that what in the broad public is discussed, and such kind of ideas are immediately or relatively direct transformed in political decisions. And the ideas of the populist movements, rather right-wing but also left-wing populist movements, are the ideal to restrict or to representative democracy, which are filtering the ideas, to rather to direct democracy without or very weak filters. And whether this kind of politics is an achievement, or on the other side, as we are saying, like backsliding of our state order. So we can then see that this kind of populist politics are relatively short-sighted, and there is not possible to have a strategy which is necessary for democratic states in the current world, in the global world, where democracy is also not only challenged from inside, from populist movement, but also from outside. Only there was some colleagues said that only 1/3 of the world population are living in the real democracies. Only 2/3 are living in non-democratic states, and the tensions between these two worlds are increasing. And I think it's very dangerous because then the resilience of our political order, democratic constitutional state, will go back, and our order will become rather fragile. I will stop here, and maybe we can ask what to do. What is possible to do? For example, we heard that in Germany there already is in prevention of possible, so to say, populistic majority. There should be some changes in constitution which will hinder, so to say, the attack to the constitutional court, so the position of the constitutional court. Maybe we should come back to the idea of during and this, immediately after the Second World War, the idea of self-defending democracy, of militant democracy in English, or Wehrhafte Demokratie in German. But this is, consists of two situations: when the problematic political forces are in minority, so the anti-democrats are in minority, it's more easier. But how to do when they are in majority, when they control the parliament, the government? I think we should also think in these terms. So I will stop here. I will give now the floor to the President of the German Constitutional Court, Mr. Harbarth, and this concept of Wehrhafte Demokratie, or militant, or rather I would say self-defending democracy in Latvia, and saying self-defending, it sounds better as militant democracy. Maybe this idea could be used also in this crisis, or other ideas how we can how we should go out from the crisis. The colleague said that she managed Spanish to go into trouble, but not out of trouble. Now we are going into trouble, but we maybe will manage go out of trouble in this discussion. Thank you. Yeah, please then. Yeah. Ah, yes. Yes. Excuse me. So we have three panelists, except me, also Mr. Anthony Kennedy, Justice Kennedy. We are paying tribute to him. And first, before discussing the trouble with democracy and rule of law, we will hear the video of Justice Kennedy. What is his opinion, his thoughts? What is rule of law? What is rule of law? Anthony Kennedy, please video.
Greetings once again. These are some informal remarks of the kind that we usually have when we have a discussion together, where you can ask questions, make comments. But let me address you for just a few minutes on a subject that may inspire you to have a further conversation among yourselves. You've received a rule of law bookmark, which we sent to you. The origins of this date back some 20 years, when I was on one of my short teaching visits to China. We were at a university, and my best recollection is that it was Renmin University. And of course, like many judges, my beginning was somewhat pompous, saying, "I'm here to tell you about the rule of law." And one student raised his or her hand, and there were probably 500 or 600 students in the room, and said, "What does the rule of law mean?" And it had never occurred to me to define it. And so my answer was that it's in 3 parts. And later, the United Nations asked me to write it down, which we did, and it's been translated into many different languages. That should not keep you from telling me in later correspondence, if you choose, that it's incomplete or unclear or that it should be supplemented. We wanted it to be short so that we could think about the rule of law, and as you know, it's been translated into many different languages, which we hope you have at your conference. The first precept, and there are 3 parts. The first one is that the law is superior to the government, and the government is bound by the law. And this means officials at the lowest level who must obey the law. The law shouldn't be secret. Now you might say, well, what if the law is unjust? Stalin killed millions of people. What if he said, well, this is the law as I gave it. Mussolini made the trains run on time. But that's not the law as we do know it or as we ought to know it. And a government that uses law as a monopoly to direct its citizens' lives can be terrifying. So the first paragraph, in effect, asks us to read further and indicate what should the law say. And that brings us to the second paragraph. And a key part of it is that the law must respect the dignity of persons, of all persons. To begin with, that's an essential cornerstone for us to have a conversation with each other. You know, Americans talk often about the Constitution, and we think of the Constitution with a capital C. A capital C to indicate we're talking about the Constitution that was drawn in Philadelphia in 1787 and enacted in 1789. The Constitution that defines us as a people. You can't talk to an American lawyer for very long, or an American citizen, we hope, without hearing about the Constitution. It defines us as a people. And it does preserve what we seek to express in paragraph 2 the dignity of all persons. Now, writings about the dignity of all persons are nothing new. Mencius, who was a Confucius student, wrote thousands of years ago. You've heard me say before at your conference, perhaps in New York, that Mencius has the same relation to Confucius as Plato did to Socrates. You wouldn't have heard much about Confucius, or nearly as much, if it weren't for Mencius. You wouldn't have heard about Socrates, or nearly as much if it hadn't been for Plato. But in any event, Mencius, centuries ago, gave this question, posed this problem. A stranger from a distant part of the nation is walking through the countryside and goes by a farmhouse. It has a well, a water well, and he sees a little child crawling up the wall of the well and ready to fall in. Does he have a duty to run and rescue that child? This writing shows that in ancient China, there was a recognition that each person has a morality, a moral sense, a moral decency of his own, of her own. And that is what we try to capture in paragraph 2. The dignity of persons is essential to the rule of law. John Locke explained that you can't have a civic dialogue unless you respect the voice and the personhood and the natural rights of your fellow citizens. In the American and Anglo legal tradition, the Magna Carta is of tremendous importance. It was in the year 1215. Before then, most every legal documents, and there were some wonderful constitutions, were written in a way that the state gave the persons certain rights. Magna Carta said, no. Persons already have rights. It's persons who give the directions to the government, not the other way around. That's the meaning of Magna Carta. And this bookmark seeks to reflect that. The last, and we could go on and on about the meaning of dignity and what law must mean. It doesn't mean that Stalin can kill thousands, millions of people, because there's a human dignity there. Then we say that the law must be accessible. My law clerk is here listening to us. One great prerogative of members of the judiciary, the federal judiciary in the United States, is that we have wonderful young people working with us for a year as our law clerks. And he made the comment to me that lawyers are ambassadors to the law. And it seemed to me that this is a very apt description of the purpose and function and duty and aspirations for lawyers who meet with their clients. They are ambassadors to the law. Javier Cremades by his leadership of this great Congress is a splendid example of this. Thank you again, Javier, for making this association and its dialogues and its meetings so accessible to all of us, accessible to each other. There's a book on the law of the American legal history, it's in its 5th edition now by Kermit Hall, American Legal History. And if any of you are interested, it looks like a great big, and it is a great big long book. It looks like a great big long book, and it is. But it dates from the Middle Ages and goes through modern times. This is in the 5th edition by Kermit Hall. And they're very short sections and paragraphs summarizing so much of what our legal history is. And one of the quotations he has is from a writer who said, "We must not be deaf to the voice of justice." And one of the reasons that you meet here, one of the reasons that so many of us are proud of your association and value it so highly is that you know we must not be deaf to the voice of justice. Do we know what justice means? Not altogether. This is an adventure, an ascent, as I've said before, an avenue, a path that we find together over time. It is sometimes difficult to see injustice in your own times. But that is what the law is designed to counter. And that is what your association has as one of its great purposes. So once again, we wish you well, and please be assured of the high respect that so many of us have for you, for who you are, and for what you do to preserve the rule of law. We meet here as friends, you meet here as friends, and we hope that friendship becomes even closer over time. And we hope that between this Congress and your meeting in the Dominican Republic, we can talk often about how the association might better bring the idea of justice and the rule of law to every nation. Best wishes, and thank you very much.
Lawyers are ambassadors to law. Thanks to Justice Kennedy for his thoughts on the essence of rule of law. And now I will give the floor to Judge Harbarth from Bundesverfassungsgericht, Constitutional Court of Germany. Thank you.
Thank you very much, President Levits, President Cremades. Ladies and gentlemen, thank you very much for having the opportunity to make a few comments following these very moving and touching remarks by Justice Kennedy. Since we have a very strict time schedule this afternoon, I will shorten my introductory remarks a lot and only make a few very general comments. I think when discussing those big issues President Levits raised, we should go back to the source which has developed and shaped the Western world over the last 2 to 3 centuries. Our understanding of freedom in the Western world is derived from the historical intellectual achievements of the Enlightenment. According to Kant, the Enlightenment was man's emergence from his self-imposed immaturity. And immaturity means, in this sense, the inability to use one's reason without being led by another. Based on these concepts of the Enlightenment, we see 2 things in particular. The first is from an institutional perspective, freedom in the sense that the will of the state would not be, as it was in the earlier age of absolutism or as it is under dictatorship, predetermined from above, but instead that the people themselves, the demos, would freely form the will of the state from below. In this regard, the concepts of freedom and democracy are closely interlinked with one another. In the German constitution, in the basic law, we have this very important provision: all state authority is derived from the people. And the will of the people is formed according to the principle of majority rule. That said, in a free state, even the power of the democratic majority must be subject to limits. As early as 1835, Alexis de Tocqueville illustrated in the first volume of his work, Democracy in America, that a democracy without the rule of law's protection of spaces of individual liberty is in danger of slipping into a tyranny of the majority. Without the guarantees of the rule of law, the democratic process cannot function in the long term. And for that reason, I think the rule of law in relation to the democratic principle has 2 main functions. One main function is to limit the democratic will. And on the other hand, it is not only the limit to the democratic will, but it is also the basis of the democratic will. If there is no right to free speech, if there is no right to assembly, then democracy cannot really work. But even if democracy could work without liberty, we did not want a system of democracy without liberty. Because exactly what Justice Kennedy said, that the old understanding that the state does not grant the rights to the individual, but the individual has the rights regardless of whether those rights have been granted by the state. That system can only work if the majority, if the democratic majority cannot do anything it wants to do. And for that reason, there is a close relationship between liberty and the rule of law. Unfortunately, some try to argue that the rule of law is a danger to liberty. But what is true is exactly the opposite. Without the rule of law, there is no liberty. If the majority can say what you have to say, what your religion is, what your dignity is, then liberty does not exist. And I think this is the most important task we have, to make clear wherever we are, to explain those relationship between democracy, liberty, and the rule of law. And of course, that is difficult in the times in which we live. I think it's difficult. I do not believe that we really understand what happens in Western societies completely. I think there are some hidden mechanisms, hidden processes we do not really fully understand. But we see that the trust of people in institutions, that the trust of people in the competence of the Western system to solve the problems the states and the societies are confronted with, that trust is lower than it used to be decades ago. Of course, we have a lot of problems because many ask, would we be better off in an authoritarian world than in the Western model? But I think we have to make clear that our heritage by the Enlightenment cannot work in the present and in the future without the rule of law. There is no democracy without the rule of law. There is no liberty without the rule of law. And if we make clear that those ideas are inextricably linked to each other, I think then we have the chance to convince people that we have to defend the rule of law.
Thank you very much. And now the President of the Slovenian Constitutional Court, Mr. Accetto. Thank you.
Thank you very much, President Levits, and also knowing that we just have 7 minutes before we absolutely need to break, allow me to encompass you all in a general greeting to the dear fellow servants and friends of the law. I say fellow servants because we all share the aspiration, that is the common theme of this conference, that the law should rule. And we have heard from Justice Kennedy what that means. And actually, just to comment at the beginning, very briefly, I think his 3 points, I actually recognize them in the symbols of Lady Justice, Justitia, as the embodiment of the law. The sword of justice, they're not the rule by law of a government above the law, but the rule of law, which also binds the government. Protecting the dignity and the rights of all, and affording them access to justice, a mechanism by which to enforce those rights. The modern-day liberal jurisprudence would summarize this as the commitment to the notions of entitlement, justice, and rationality. And it is a very common endeavor that we all know and share. We sometimes see it challenged to different degrees of severity, but we absolutely do share it across the globe. And what I want to do today, because I think the responsibility for the challenges, of course, falls down on the 3 actors in the triad of those directly concerned by the operation of the law, the courts themselves, the political branches of government, and the general public. And of course, it starts with the courts doing our job properly, and we've talked about this morning, the independence vis-à-vis the political branches, impartiality vis-à-vis the parties to the case, and objectivity or neutrality vis-à-vis the applicable law and one's own, judge's own conceptions and worldviews. And of course, there are open attacks, either by populist movements, by the political branches, which may wish to openly attack the courts or ignore the rule of law. And there may be more or less insidious ways of trying to obviate the requirements of the rule of law. But what I wish to add as a footnote to all these discussions is a few ideas, snapshots of the ways in which the rule of law is challenged even by the well-intentioned governments, by those which do not wish to undermine it, but nevertheless perhaps do or challenge it, at least in ways which are problematic. We've heard some of them already, I think, this morning. President Zacaj mentioned the idea of judicialization of politics, of translating political conflicts into justiciable cases which are then brought before the courts. And of course, the courts must and do dispose of those cases as well, but they do come with a cost. Another example, I think, is the one where the moment of crisis, which President Levits also mentioned, comes about, when the governments, the authorities would sometimes say the rule of law should take a step back and not be a hindrance to an effective regulatory response to a crisis. We've seen this with COVID, for instance, recently, when the rule of law requirements in states which were more or less all of us caught ill-prepared for the realities and the challenges of COVID, struggled to come up with constitutionally permissible ways of reacting to the pandemic. But we've even seen it before. We've seen it 25 years ago, after 9/11, when the established standards of human rights protection, the protection of privacy, data protection, free movement, and other rights, have been challenged with a renewed, bolstered sense and commitment to security. And that re-establishment, recalculation, recalibration was also termed by some regression in the standards of the protection of human rights, which is again a topic currently also actively discussed, including the controversial Dobbs decision in the States and the implications of that decision for revisiting other, perhaps, elements and rights and the way the jurisprudence has dealt with them. So there is that element. And of course, for the proponents of those rights, that is problematic in itself, but it also confronts us with this reality, and I think both my co-speakers have already mentioned this, that there are constitutional values we earnestly and rightly hold, which may be in competition with one another. The similar concept to the security of post-9/11 world in Europe, European Union, the area of freedom, security, and justice, is a concept of three values that perfectly soundly work as each on its own, but may be somewhat uneasy bedfellows. And the same with values in Article 2 of the EU Treaty and the constitutional underpinnings that President Levits has mentioned, human rights, democracy, and the rule of law. So what is, for the final 2 minutes, what are the courts to do? The important thing we can do and we should do is to keep doing our job properly. We should not be engaged in politics. I am reminded a little bit of what Mr. Arias said when he mentioned this morning the discussions between Putin and Xi Jinping. We absolutely should not engage in that sort of thinking and rhetoric, and I was reminded of what the president of the Constitutional Court of Russia said before Russia's departure from the Council of Europe, when he said, not all rights of the European Convention on Human Rights should be given full effect in Russia because some of them are simply not compatible with the Russian soul. I will leave that there. But I will finish on a hopeful note, and I will go back to the States. I welcome Justice Sotomayor, because sometimes a crisis is also a moment for reflection and a moment to actually to try and develop something. And for the courts, I'm often reminded, and I will use it again, I think most of you may have heard it at one point or another, but there was a wonderful statement once put forward by Martin Luther King Jr. in a different setting, in a different context, but one that always gives me hope, also for law and the operation of the law. He said, the law cannot change the hearts of men, but it can change the habits of men if vigorously enforced. And if vigorously enforced, over time, the attitudes will change as well. And perhaps in the long term, the hearts themselves may change as well. So as we go back home and we continue doing what we've been doing and we hope for the best, we certainly won't see it overnight. But as judges, what we can hope for is the long term. I thank you very much.
So thank you, Judge Accetto. Welcome, Madam Justice Sotomayor. I will conclude. I will conclude thanking Judge Harbarth, Judge Accetto, and Justice Kennedy. And we can only say that we, as lawyers, are convinced that a rule of law is necessary as an infrastructure in order that we can work. But we should convince also the people outside. Also, because now there are certain arguments that they are saying just rule of law is too restrictive for democracy. But as Judge Harbarth rightly said, rule of law is the basis that the democracy can function. And also this argument, we should be more loud in order to convince the people. Thank you very much, and all the best for you.